Okay, welcome everyone, and I would like to welcome back our speaker who has presented to us before. Sarah Marmore is partner at Scharf Banks Marmore, a trial lawyer, employment litigator, and client counselor with 3 decades of experience successfully representing sophisticated clients on many of their most difficult and sensitive issues. She's tried complex commercial cases and appeals throughout the county in both state and federal courts. Sarah currently heads the firm's employment counseling and litigation practice. She provides advice and counsel on all potential aspects of an employee relationship, including employment contracts and non-compete and related restricted covenant matters, which of course is the topic of our class today. She also handles discrimination claims, wage and hour issues, background checks, leave policies, and law diversity initiatives. So, Sarah, with that, I will turn it over to you.
Thank you, and welcome, everyone. Thank you for letting me talk about one of my favorite topics. I'm a little bit of a nerd about non-competes, or really, I should call them restrictive covenants. I tell everybody to call them restrictive covenants. But what I want to talk about today is really trends and limits with some guidance about the basic law in this area and what we mean when we talk about restrictive covenants. So here's our agenda. I'm going to talk first about trends. Then I'm going to give a brief overview of restrictive covenant terms. And then we usually talk about art and science, but I'm going to invert them and I'll talk about the science first, which is really the legal rules. And then the art of a restrictive covenant matter, how practitioners really deal with these matters, because they're both fact intensive and they involve personal relationships that either are good or bad. And usually when somebody's leaving a job, there can be resentments on both sides, I guess is the way I would put it. But there can also be a willingness to work things out because you've worked together with each other before. So first, the trends. The last time I spoke, probably not to you guys, but the last time I spoke about restrictive covenant laws was about a year or so ago. And at that time, there was a lot of action in the world of restrictive covenant law, in significant part because the FTC had proposed a rule that would have banned almost all non-competes in the United States. And there was at the time also an agreement between various agencies of the government, including the FTC, the NLRA, NLRB, and the Department of Justice. They were all banding together to think about restrictive covenants and what to do about them. All of that has gone by the wayside, both because there were a number of immediate legal challenges to the ban, and then a new administration came in. And although there actually was some interest on the part of some Republican senators to keep the new rule in place, ultimately the FTC decided to abandon it. At the same time and one of the reasons that people argued against this new FTC rule, there was a lot of activity at the state levels in various states around the country where they were banning non-competes at least. That energy seems to have also waned a bit. It was pretty well publicized that in New York was poised to have a pretty extraordinary new non-compete ban that would have banned non-competes for anybody making less than $500,000 a year, which would have been the highest threshold of any state in the country. And ultimately, I think probably because of, at least reportedly, because of lobbying to the governor, she indicated that she would not support the statute, and it effectively went away. Now, so since then, there have not been any really major new state laws that I've seen about this. What's really happening now is that, and I think it's kind of coming to a place of a little bit of stability, in part because employers did react to the first 2 points here as state laws were changing, as the FTC was taking an interest, a lot of employers reached a conclusion that maybe non-competes were not the best thing for them to be pushing on their employees. And they started to focus more on non-solicit and confidentiality rules. And so I think I would say that both the pace of change and the pace of litigation have fallen a bit. And now really what's happening is that there is a focus on salary thresholds, dollar thresholds for who can be subject to these kinds of agreements and the types, and in some states, the professions, there are certain professions that no longer, with some variation, that no longer are subject to non-competes or non-solicits. I do like to define terms for people because, and especially if you've ever had a client call you up and you say, well, what kind of agreement do you have? And they'll say, well, I have a non-compete. And then you end up reading it and it's not actually a non-compete, it's a non-solicit or something else. So I like to define our terms. We have first confidentiality and trade secrets. Almost everybody who works for a company of any size will have signed a confidentiality agreement at one point. And also, most people are given access to some level of trade secrets at companies they work for. So even if there is not a more explicit restrictive covenant agreement, you can have employees who, let's say, they take things off of a computer before they leave. They take customer lists. They take exemplars of work that they did that may include trade secret information. Almost everybody in the professions is likely to be bound by a confidentiality and or a trade secret agreement. And there are also federal and state laws to defend trade secrets that you have to pay attention to. In Illinois, you have to be careful that you don't say everything about our business is confidential. And if you take anything about our business, you will have violated your confidentiality obligations to us. An agreement like that not only is going to be overbroad, but a court may decline to blue pencil it to make it more, let's say you really took something that was confidential, but you have a confidentiality agreement that's so overbroad that it doesn't really inform the employee of what they're supposed to keep confidential. So you want to really think about if you're writing one of these kinds of agreements or if you're reading them, you have to ask yourself, all right, how does this actually line up with this business? And how would an employee know what was confidential and what wasn't? Even if you don't have a confidentiality agreement, as I mentioned, this is the Defend Trade Secret Act, which we call DTSA. DTSA is something that it's within the last decade or so was passed. There's not a million decisions about it. But the basic standards for application of DTSA are that it is something is a trade secret. It doesn't actually have to be, computer code or a method that we would all think of sort of automatically as a trade secret. It can be a whole host of things, but you have to be able to prove that you kept it secret and that you told employees that it was secret and that it isn't otherwise available out in the world. The next category is non-compete. This is the most restrictive agreement you can have. It says you can't compete with us. You can't go work for a competitor doing the same thing that you were doing for us. Those are the hardest to justify because they really are a restraint on trade. They have to be narrowly tailored. You can't say if you work at Coke, you can never go work for Pepsi. It has to be narrowly tailored to the things that you did at Coke. You can't do those things at Pepsi. And most of the time, the question for the practitioner who has a non-compete agreement in front of them is, all right, what is it that you did at this company? What is it that you're going to do at this company? Is there an overlap? I think the days of saying you can't work in this industry or you can't work for X competitor in any capacity, those days are really over. The next one is non-solicitation of clients in terms of importance. The way I like to think about this is, would it be unfair to compete for the same client for a new company? Do you possess, and I often think about this in terms of what knowledge the employee possesses. Do I possess knowledge of the methods, the staff, the pricing, the capabilities of what's now my former employer to whom I'm becoming a competitor? If that's true, then a court will say, well, then it's probably not okay for you to compete for the same employees because you have insider knowledge of your competitor that would be unfair for you to use. One thing that a lot of employers make the mistake of doing is saying you can't work for any competitor of our company. Um, no court is going to allow that. What they will say, and if you have that broad a provision, what a court will probably say is, well, no, you can't work for the clients that you worked for, that you had direct contact with, that you possessed this information about. Um, but they're never going to say that you can't solicit clients who you never actually had any contact with. A note here too, sometimes non-solicitation provisions will also say you can't service that client. This is an important point of distinction because if it's just a non-solicit and you leave one company to go to another and a client reaches out to you and says, I hear you left company A and now are company B. I really like working with you and I still want to work with you. As long as you did not solicit that that interaction, and maybe expensive to prove this, but as long as you didn't solicit that interaction, you're allowed to then go on and service that client. That's why you always want to look at the question of whether or not it says you cannot solicit them, nor can you provide services to them. Now, if there is a no service provision, courts are going to look at that with a bit more of a gimlet eye than just a non-solicit. But there are those kinds of provisions out there, and you have to, as with all restrictive covenants, you have to demonstrate that it's necessary to your business, that you have a legitimate basis for trying to impose this on someone. The last one is non-solicitation of employees, which generally is not as controversial or difficult to manage. Think about it this way. If I'm working at company A and I have a bunch of people working for me and I know who the best people are at company A, and then I go to company B and I say, hey, company B, you should hire, these three people because they were the top earners, top salesmen, top whatever. It would be unfair to use that kind of inside information to solicit people to come to the new business. This is an area where, however, employers get really irritated and are more likely to go after a departed employee if all of a sudden there is an exodus of people to the new employer. And so we'll talk a little bit later about best practices to avoid that. But it's unfortunately a lot of people in the business world just don't pay attention to these restrictions. They don't think about the fact that maybe, somebody calls them up and they're a friend of theirs and they want to say good things about the new company, or the person calls and says, I hate working at company A. How is it at company B? And then you pass that name along to somebody. These are the pitfalls and the dangers. And then, of course, for the company itself, for the new company itself, if they were aware of an agreement like that and they accepted that kind of information from a new employee, they're at risk of a tortious interference with contract claim. So you want to be careful about that. The key question really, except in jurisdictions where at least some of these types of restrictions are banned, the key question is always, does the covenant reasonably protect an employer's legitimate interests? And courts will look at things, and they'll certainly look at how it's written. They will look at geographic limits, although in this day and age, geographic limits are becoming less and less meaningful. They will look at the amount of time, although I will say that I don't know of any state off the top of my head that has a hard and fast rule about how long these restrictions can last. And then they will look at the question of the type of restriction that the covenant includes. If it, again, if it's overbroad, if it basically means the person can't work in their industry of choice, it's probably not going to be upheld. And again, the legitimate interests, that becomes a very interesting debate about what's a legitimate interest. I'm not going to go into it deeply now, but you always want to be thinking in those terms. So let's talk about the science of a restrictive covenant. I'm going to go through this fairly quickly. You're all going to get the materials at the end, and you'll see these points made in there. But in most states, if the agreement is reasonable, what you really need is some good facts to demonstrate that they have violated the agreement. In Illinois is actually one of the most restrictive states, and we'll talk about that in a second. New York has a pretty helpful way of thinking about it, which really is tied to confidential information, the inevitable disclosure doctrine. California is the hardest state in the union to have at least non-competes and non-solicits. Massachusetts has a kind of its own interesting rules. Washington State, it says it's newish. It's actually at this point not that new, but it is a really restrictive statute with a lot of interesting aspects to it, but hasn't been it hasn't had as much play as I would have expected, given that it was a fairly novel statute when it was passed. Minnesota, a couple of years passed out of the blue a total ban on non-competes, and it's retroactive. So at this point, if you've got a client in California, in Minnesota, who has a non-compete, you should probably tell them that it's not enforceable, with some minor exceptions. I've already talked about the restrictions, the type, the scope, and the length. And then you want to think about how to comply. Illinois rules several years ago, after a period of uncertainty in Illinois, in particular over a case called Fifield, which had said, it was a state court case that had said that if the employee has not been working for at least 2 years, if the employer did not pay extra consideration for a non-compete or a non-solicit, it is unenforceable. Federal courts for years afterwards pretty much refused to apply that quite bright line rule. And finally, the Illinois legislature codified the rule along with some other rules. And so largely at this point, if you've got an Illinois restrictive covenant agreement, you'll be able to look to the statute more than anything else to decide what's allowed and what's not, and whether or not it's enforceable. So the factors that are codified in Illinois is that you have to have extra consideration or 2 years. And the question of what extra consideration is a really interesting one, because no court has fully decided it. In theory, it could be as little as specialized training. It could be a cash payment in return for the agreement. Although the amount of that payment is unclear, and I've suggested anywhere from $1,000 to $10,000, depending on the position and the employer. The one piece of consideration that I really do think is undeniable is if the employer has a bonus system or issues RSUs, restricted stock units to employees after they've joined, you can make the receipt of that contingent on signing a restrictive covenant agreement, and that will undoubtedly, I believe, be sufficient consideration. There's also signing bonuses. I faced an interesting case where there was a signing bonus that was void if the person left within a year. The person did leave within a year, and the question was, if you give up the money that was the consideration for the restrictive covenant in the first place, was there really consideration for the restrictive covenant? And at least in one case, the court, it was a federal case, and the court sort of didn't buy that argument. So, I always ask when I'm talking to either an executive who's trying to leave or a company that's trying to stop an executive from going to a competitor, was there consideration for the agreement? You have to ask yourself, is the restriction no greater than required to protect a legitimate business interest? There has to be no undue hardship on the employee. And I want to pause on that because there's a kind of interesting wrinkle. Not every state has that standard. Illinois does and New York does. Florida famously does not. And if you have a case where somebody is an Illinois resident and has a Florida non-compete or restrictive covenant agreement, courts in Illinois will not at all, at any level, enforce a Florida restrictive covenant agreement because the standard is, I just recently read this, is obnoxious. So I had a case where I came in late after a TRO had been granted to a Florida company against an Illinois employee. And when I pointed this out, they dropped the case. So it's a fun way of getting out of these things. And the final element is that it's not injurious to the public. In general, that's not usually a big issue. I talked about the 2-year or other professional or financial benefits rule for consideration. There is for the non-solicits, it talks about there's a totality of circumstance standard for legitimate business interest, but also for non-solicits. There's some debate about whether or not you have to show as the company that you have a near permanent relationship with the client to justify having a non-solicit. That used to have more play, interestingly, but now because it's a totality of the circumstances argument, I don't think it's as much of a killer as it used to be. But it's a factor that you have to think about. The salary thresholds, I think these still stand. They may have gone up this year, but the initial salary thresholds for non-competes was $75,000 and non-solicits was $45,000. I think they're about to go up by about $2,500. You must advise the employee in writing to see a lawyer and give them 14 days to consider, but they can sign it before then. There's blue penciling allowed. There's some pandemic rules that I'm not going to go into. But the other big change in Illinois was that attorney's fees can go to the prevailing employee. Most employers have for years had we get our fees if we have to go after you for this. But in Illinois, the employee also, by matter of statute, can get their fees if they win. New York follows what's called the inevitable disclosure doctrine. There's a famous case called Visentin brought by IBM against one of their main executives, now probably 20 years ago, that set this standard. And the standard really is the question the court asks is, will you in this job inevitably disclose confidential information that you gained from your prior employer? That really becomes their standard. And most employers, well, certainly IBM has now put that standard in their agreements. They learned the hard way. But if you're looking at a New York agreement, you want to see whether or not they have that language and whether you can make some hay if they don't. New York courts, this is an important point. This used to be a bigger point for California employees, and for a long time, New York courts were saying, we don't care if the employee is from California. If there's a New York choice of law, we're going to apply New York law. I think that's less likely to happen today, but be aware of that. And again, I've already talked about the question of whether there's a substantial overlap between the roles. That's really what the Visentin court said. It was the inevitable disclosure plus, is there substantial overlap? Because those two really go hand in hand. California, I like to say, is the gold standard, with a pun intended up above. By statute, most non-compete and client non-solicits are illegal and void. That makes it broader than a lot of states. A lot of states outlaw non-competes, but not client non-solicits. Employee non-solicits still are enforceable in California. Um, California, I mean, all of this, by the way, in California is by statute. So there's a statute that says that that if you work for a company that has, say, a New York choice of law, California, that's unenforceable against a California employee unless the employee had a lawyer advise them about the agreement before they signed it. There are some exceptions to the rules in California. I'm going to talk about them because they generally apply to many states. So I just put a pin in that. The other interesting thing that's happened within the last couple of years was a new statute was passed in California that said that employers who had restrictive covenant agreements, meaning non-competes or client non-solicits with California employees, had to affirmatively write to their employees and say, we're letting you know your agreement is not enforceable. This, I think, is part of why a lot of big companies that might have tried to enforce these agreements in other states are now not going to, because they were facing some real penalties if they didn't tell their employees in California, these do not apply anymore. And so that's a big deal. And I think that, as I said, I think that explains why things have sort of settled down there. Massachusetts is sort of weird and interesting. Their employers have to offer the employee paid garden leave. Garden leave is basically you are still an employee, but you're not working. You're sitting in you're tending to your garden for some period of time. And it's a British term, and Massachusetts, having its roots, probably decided garden leave was a good term. But anyway, you have to pay them 50% of the period that they're out, that they're under a non-compete. You have to pay them 50% of their salary, and they take 50% of the highest base salary in the prior 2 years. Most employers that I've seen in Massachusetts, basically, they decided it's not worth paying people not to work. And so they will let that go. And so non-competes are less likely to be enforced as a result. This was a precursor to what we're seeing in terms of salary limits. Because the Massachusetts law is now close to a decade old, cannot require non-exempt workers to sign a non-compete, and it's not allowed for certain professions. You cannot impose a non-compete if the person was laid off or terminated without cause. Now, the without cause question is an interesting one because, and New York actually also has this law. It's common law, and it only applies to some parts of New York, which is super crazy. But New York City is covered by it. But the question of whether or not, for example, poor performance is cause in New York is now open to question. So I wouldn't get too excited about that unless it's very clear that it was a layoff or a RIF or something like that. Here, Massachusetts is one of the few states that limits non-competes to a maximum of 1 year. And the idea is that they must exist. Sort of the reason for them must be that you're protecting statutorily covered employer interests like trade secrets. I said Washington State was kind of a big deal when it came out. All not all non-competes of more than 18 months were presumed to be unreasonable and unenforceable. You have to sit, just like Massachusetts, you have to be compensated during the restricted period if you were terminated due to a layoff. Agreements that require the application of non-Washington law or adjudication, a venue outside of Washington, are deemed void under the statute. I was involved in one of the first cases where that became an issue. It was here in front of Judge Kokoris, and he just didn't buy it. I was not the actual lawyer in the case, but the lawyers in the case, interestingly, were the ones, they were from Washington State and had actually been involved in drafting this law, and they couldn't convince Judge Koukouras to impose this Washington provision. So, that's a bit of a surprise. The other really big interesting thing is that it's retroactive, and employers face penalties, legal penalties, financial penalties for covenants that do not comply with the new law. So I would have expected more litigation out of it, but there just hasn't been that much. Minnesota, as I said, a couple of years ago, out of the blue, enacted a near total ban on non-competes for employees and independent contractors. Arbitration, if you have an out-of-state choice of law or forum selection, those can render the entire agreement void, and out-of-state arbitrations are barred. Although a lot of people wonder if that really can happen, given that the Federal Arbitration Act may supersede that. But again, I haven't seen much fighting about that. And for now, non-solicits and confidentiality agreements are allowed. So as I said, what there was a lot of activity. It seems to have died down. Now the focus really is on specific professions and salary thresholds. I've given you a few states in which the big one is doctors. In a lot of states, people in the healthcare industry, doctors, I presume nurses as well, it's getting harder and harder to impose non-competes on them. I think for the natural reason that non-competes and non-solicits of clients, patients want to be with their doctors, and if your doctor goes somewhere else, the patient ought to be able to follow, and the doctor ought to be able to give service. And the non-competes, physician non-competes, I've done a lot of them in Illinois, tend to be within 10 or 20, maybe sometimes 50 miles of where the doctor was practicing. In an urban, a dense urban place like Chicago, that could be a real problem for a doctor. And so I think it's understandable that physicians are a big focus. One funny thing about Illinois is that construction workers are also people in the construction industry. I'm sure they've got a great lobby because this is a long time thing, are also exempt from restrictive covenant agreements. Where the real action is the salary thresholds. And that also, where interestingly, has its genesis in Illinois, because there were a bunch of cases, again, a decade or so ago, where people who worked for fast food places, the main one was Jimmy John's, were being subject to non-competes where you couldn't leave one Jimmy John's and go work for either a different Jimmy John's or for a Subway. And these are people making sandwiches at probably minimum wage. And the Illinois Attorney General had a problem with this, and it led to some class actions. And eventually, it really led to this movement of what are we doing here? We should not be imposing these kinds of agreements on people that aren't making a lot of money. Now, what a lot of money is of course in the eye of the beholder. But the examples that I've got here from Colorado, DC, Oregon, and Washington give you a sense that it's likely to be at least the six figures for non-competes, and lower, significantly lower for non-solicits. Note that in Washington, and this is, I think, relatively unique, that they have a really high dollar threshold for independent contractors of $308,000. One interesting question that I don't have the answer to is, increasingly in a gig economy, what's going to be happening with these non-competes for independent contractors? They exist. I've certainly seen them. And really, again, it has to do with protection of the confidential information that you're showing the independent contractor so they can do the work for you. But if there were any area that I could imagine there being a kind of new wave of statutes, that seems to be one. I mentioned that there are exceptions in California, and in fact, there are exceptions in pretty much every state to the limits on restrictive covenant agreements. Sale of a business is a huge exception, usually in part because the people who are selling the business are not employees, they are owners. And so some of the same kinds of concerns about protecting employees just don't apply there. So by and large, a lot of the limits on restrictive covenants are ineffective where it's a sale of a business. And I've certainly seen in sale of business circumstances non-competes and non-solicits of as long as 5 years. And that's 5 years from the time you leave. So you have to think about a business owner who sells the business but stays on and 5 years later leaves. And then they've got a 5-year non-compete or non-solicit. So it's something, if you're involved in that kind of agreement, you want to make sure that the sellers understand what they're signing up for. Partnerships, for similar reasons. In partnerships, in California, for example, and in most states, if you're a partner, you're an owner, you're not an employee. So the statutes do not protect you. Forfeiture for competition is another big area in certain industries where they'll say, sure, you can leave. We don't have a non-compete. So instead of a non-compete, what we're going to do is we're going to keep a whole bunch of money that we're either going to take your RSUs or we're going to take back bonus money. In a lot of these big companies that have where they delay payments of bonuses and the like, there will be an account that they hold so that they don't even have to come after the employee to get the money. They'll just say, we're keeping this money. And there was a big case in Delaware a couple of years ago where partners left and they were owed money as partners. And the company said, oh no, we're not going to pay you that because you've gone to a competitor. And they thought that they had an absolute right to that money. And the Delaware court said, we're not applying a reasonableness standard to this at all. If you're a partner and you leave, the partnership can refuse to pay you money that you think you are owed. Again, that's something if you're advising somebody who's thinking about leaving, they need to think seriously about that. I will tell you that where it's somebody going from one big company to another big company, now that this is relatively baked into the cake, what the executive can and I would say should do is talk to the new company about what they're giving up by coming to the new company and say, I'd like you to make me whole. The new company can do that as a cash payment. It might do it as a signing bonus that is contingent on the person staying for a period of time, or they can do it in the form of issuance of stock units that also will have a vesting period so that the person, if they come and they leave after 6 months, you're not left having paid them, say, $1 million that you can't recover. Also, a big exception to whether or not, for example, in California, one of the big exceptions in California to this ban on non-competes and client non-solicits is if the employee has stolen something, if they've taken a trade secret, California courts will punish those employees by imposing some sort of a restrictive covenant if that happens. And so, you'll see when I talk about the art of all of this, that you really want to make sure that the candidate who leaves is not leaving with stuff that they shouldn't have. All right. So we're going to talk about the art. The first question, whether you're working on the part of the executive who's leaving, the company who he's left, or the company where she's going, you want to gather the right information. You should always ask for any employment agreements, any non-competition agreements or restrictive covenant agreements, any RSU or other equity agreements. That's really important because the restrictive covenants can actually not be in a standalone agreement or even in the employment agreement. It can be in the grant of RSUs or the grant of a bonus. So you want the whole 9 yards. You don't want to assume that you've seen everything until you really plumb these depths. Then what you want to think about, first, you definitely want to think about and I'm going to do this a little bit about out of order, but if there's a non-compete, the first question you want to ask is, all right, what's the overlap here? Are you doing the same type of thing for the competitor that you're doing for this company? Then, if you're happy with that answer, you want to ask the question, all right, who are the clients you can't solicit for whatever the restricted period is? I call that the hands-off list. Who's hands-off? Now you want to think about what hands-off means. Hands-off may just mean don't call them and say, hey, I've left Pepsi to join Coke. It could be literally hands-off. I can't even work for this client for the period of the restriction. But you want to ask that question. You want to talk to whoever, no matter where you are in the panoply of potential parties here, you want to ask those questions. And then you also want a copy of the resume, because that will often include the home address of the person that is leaving. And that will tell you something about what law you want to look at, either instead of or in addition to Illinois law. And often the resume will describe the things that that person has done. Now, the other point I want to make is that don't rely solely on the puffery of a statement in a resume. Don't rely solely on the incredibly overly broad description in a written job description. You want to think practically about what this job is. Because if you rely only on resumes or only on job descriptions, you're going to find that it's very hard to justify justify the person going to the new place. We've already sort of talked about all of this. The third point on this slide is I always say to an executive that I'm helping, be Caesar's wife. And for those of you who don't know what that refers to, is that at the time of the Caesar's wife had to be more virtuous than anybody else by virtue of her position. What that means is you want to make sure that when you're leaving, you tell the employee, don't just take down the things that you think belong to you from your computer. Tell your employer, there are things that belong only to me on my company devices. I would like to keep those. How do I do that? Because what you don't want to do is set off suspicion with the company that the employee is leaving. Because the minute their faith in the employee is gone, it becomes a much more difficult conversation. This goes to my point about look for practical workarounds. Litigation is really not the first thing you should be thinking about. You want to think about what are the relationships here? How can we work something out? Are these companies that have kind of revolving doors where people are coming back and forth all the time? And you wouldn't want to set a standard here that you can't live up to later. I also am a big believer in talking to the employer, not hiding where you're going. A lot of executives don't want to tell them where they're going. I think that's a terrible mistake. They're going to eventually find out, and why not work it out beforehand rather than after the fact, where, I mean, for example, I had a client who got sued by his former employer 2 years after he left. We luckily got the other side to dismiss the case before it went too far. But we said to them, why didn't you just pick up the phone? The lawyer before us had tried to talk to them about it. They sued instead of talking about it. And when they finally talked to us about it, we were able to show them that there was nothing for them to worry about. But the reason that, so his was an unusual situation, but the reason why you want to talk is that you can get a waiver, and a waiver does not have to be some formal document. It's just like, hey, I'm planning on taking this job from company B. I intend to live up to my confidentiality obligations. Here are the clients that I think I can't solicit, and let me explain to you what the job is and why I don't think you should be worried about the non-compete. That coming prepared with answers before they've even asked them sets the stage generally for a smooth transition. For employers, because I tend to, even when I'm representing the executive, I'm really representing an employer as well. Employers really need to make sure that they review non-competes or non-solicits to ensure compliance with all applicable laws. The biggest concern for an employer is that they're going to get dragged in on a tortious interference claim. So they really, really need to take the time to review agreements and make sure that they've worked out with the candidate before they start why it is that they can start. Um, uh, on their own agreements, think about what the standards are. Make sure you're not like those Florida companies who can't enforce their agreements for employees that live in other states. You want to think about what are the laws that could apply to my employees, especially in this day and age when people tend to work remotely. Think about tailoring agreements and policies to protecting the employer's legitimate business interests. Explore, this goes back to my point about the forfeiture for competition. Explore alternatives to non-compete agreements that may accomplish the goal of protecting legitimate business interests. A legitimate business interest can be, for example, that it's going to be when a high-level executive leaves, and we're going to have to find replacements and make sure that we're protecting the goodwill of our relationships with that person's clients, and that's going to cost time and money. That's why a forfeiture for competition provision may be an alternative. And I would just say always continue to monitor for updates on pending legislation because the world does change. Like I said, the pace is slower, but you never know what, things come out of the blue as it did in Minnesota. So I want to talk about a few what I call frequently asked questions when I'm advising clients. A client takes my advice and says, okay, I'm going to ask for all of their agreements so that I can make sure that there's not a problem here. And the candidate is saying that the agreement is confidential and they cannot share any of it or most of it with us. Now, the truth is that position, with very few exceptions, is almost never true. It's almost never true that an employer won't let you share with a new employer the agreement that you have to abide by. There are some rare, like I said, there are rare exceptions, but it's almost never the case. Um, uh, there can be information in those agreements that it would be okay for the candidate to redact, like the salary they were making. If they don't feel comfortable sharing that, if it's part and parcel of an offer letter, for example. And if you really can't get them to agree to give you the whole agreement, at least get key passages. Say, I need to know the date. I need to know the applicable law. I need to know any venue provision. And then I need to see the actual restrictive covenant provisions. And that should not just be non-compete and non-solicit, but also confidentiality. There's been this question, I will get a call and say, okay, I've got an former employee who left us and we're getting rumblings that clients or employees are being solicited in violation of their agreement. What can we do? One of the big questions is, can you reach out to the new employer and raise a red flag with them? And the answer is yes, but you should be careful because there is a risk of defaming the former employee. You don't want to say to the new employer, Bob Smith has violated this agreement and we're going to sue him. If you don't, unless you're 100% certain that something has happened, and even then, I would not recommend saying it so baldly to the new employer. What I would say is, we want to let you know that we know that Bob Smith has joined you. Here are his restrictive covenants. We have concerns about whether or not he is complying with them, and we want to make sure you are on notice of the covenants so that you are aware that he should not be doing the following things. That often will that will surface a lawyer who says, I represent Bob Smith and the company. And then you start talking to them. The one thing I will say is the downside of asking for the agreement in advance is that one of the elements of a tortious interference claim is that you knew about the agreement and then you caused the party to violate it. I think on balance, knowledge is better than lack of knowledge because it's messy and difficult. I've had clients who have asked for these agreements. The candidate, and again, these are even the highest level executives, they don't pay attention to this stuff. They say, oh, I didn't have an agreement. And then lo and behold, 2 months later, after they've joined, an agreement surfaces that you have to deal with. And I have heard of situations, and I've seen it happen, where the executive had to leave and they can't go back to where they were. And so it really, the upside of not sharing this information and thinking about this information is I can't think of any instance where there's the upside has outweighed the downside. Um, then can we hire? The other thing I just want to say is a lot of litigants have the question in their mind of should I just if they've come to conclusion that yes, there was a violation and yes, they want to bring a lawsuit, should I sue both the former employee and the new employer? There are reasons to do both, and there are reasons not to. A big reason not to is that the new employer will have a deeper pocket than the former employee and will have more potentially more of an appetite for fighting. But as I've just pointed out, often once the person is within the new company, the likelihood is that the new company is going to provide them with counsel. One further point about that is that I have seen situations where the plaintiff in those cases says it's not appropriate for one law firm to be representing both the former employee and the new company because there is going to be confidential information that goes back and forth that the new company should not have, that should be only limited to the employee. I've just seen it in every permutation, so it's an area to be sensitive to. The final thing is there's this whole concept of, people talk about poaching and poaching groups. And there will be circumstances where a very high level executive joins a company and they're starting a practice at the company. They're starting a service area and the new employer says, I'd like to go after all the people that were working in that group at the old company. Can I do that? And the rules really are pretty simple, which is that if the high level executive doesn't have simply is relative term, but if the employee has a non-solicit, you have got to wall him off. If you've got use recruiting staff, go to places like LinkedIn to determine who was in the line of reporting in that group. Do not get your information from the executive. You have to tell the executive that if anybody calls him or her, they cannot talk about the company. They have to say, I'm sorry, I'm under a non-solicit and I can't talk to you about this. I've heard of situations where people have tried to set up a departing executive by having somebody at the company call and seeing what the departing executive says. So you really want to create a wall around the person with a restrictive covenant. In general, the big rules, and they should be fairly easy to comply with, is that you shouldn't do things that would be deemed unfair competition in recruiting an entire group of people. Like, for example, your group is all going to get laid off because Bill Smith left. So why don't you come over? That is it's kind of pushing the envelope too far. The other big example, and it's hard to imagine in this day and age that the people would do this, but there's a sort of infamous case out of Pennsylvania where a whole bunch of engineers were hired effectively just to deny their services to their competitor, but there wasn't any work for them. So they were basically put in kind of maintenance positions at the new company, which was deemed unfair competition and not a proper way of doing things. Now, of course, the risks are that the threatened company will bring a lawsuit and get very upset about all of this, and that they won't believe you when you tell them that no, Bob Smith or Bill Smith has not had anything to do with this. And you may be facing a situation where they go in for a TRO and you have to do some discovery to prove that. Again, my strong advice is to try and work it out if you've got a good story to tell, work it out in advance, so that or work it out informally so that a lawsuit doesn't get filed. So I think that's all I have to tell you about today. This is just, about our firm. But I think I can stop sharing, and I don't know if any questions came in.
Yeah,
Um,
there are some questions in the chat. Yes.
okay, great. So I'm going to stop sharing, and then I did not see the questions, so sorry. Oh, here we go. I see the chat. Okay. Oh no. Okay, good. I'm glad that the PowerPoints are still there. Okay. So Helen Block says, in the sign-on bonus context, does the document have to state that the sign-on bonus is in consideration of the non-compete, non-solicit? If it's merely a sign-on bonus without that language, would it still be enforceable? Probably I mean, the best practice is to make it clear that that's the consideration. However, in practice, if they actually got extra consideration at the time of joining, I think you would have a very strong argument that there was extra consideration and therefore the non-compete or non-solicit should be enforceable. But if I saw that situation, would I be less than delighted? Yes. But I also think, frankly, if the bonus is substantial, you're going to find judges are not very sympathetic to the argument that, oh, well, you didn't explicitly say this was tied to these added agreements. Charles Krugel asked if a copy of the PowerPoint is available. Yes, it is, and it's going to be circulated after this presentation. The question I wonder about psychiatrists, given the nature of services, I think if we expand that to psychiatric social workers who are not physicians in quite the way, because we've seen in the area of statutory restrictions. I think that's a very, very good point. And I've actually seen this argument made in other advisory professions, like wealth managers. Now, there's one case in the Seventh Circuit, really from the Northern District, and it's a fairly old case, and it was on slightly weird facts. But it was a wealth manager who was going from one wealth management company to another, and the court said, and it was at a time of volatility. And the court said, well, this is such an important relationship that it seems like this should not be an area where there's a basis to enforce a non-compete. I've argued the other side of this, which is, particularly for wealth managers, I feel like, frankly, they end up, it depends on how old you are, I suppose. If you're in your 30s and you have a wealth manager, it's not the end of the world if you're not able to work with them. But if you're at or near retirement, I can see the argument. What my clients have done in that arena is ask for money damages from the defendant, but not to stop the client from going away, and that's been pretty successful. I think a psychiatrist, man, that just seems, it's hard for me to see how you could justify stopping that relationship. The question of getting profits disgorged, I think, is an interesting one. But again, I think a lot would depend on the facts. There's another one. Oftentimes, the restrictions are in a severance agreement that contains language that the employee must keep the existence of the agreement confidential. I agree that that would drive me nuts. I think what you could do under those circumstances is redact it. And often it's either in the severance agreement, or that the other thing that's a little bit crazy is the severance agreement will say, and your prior agreements, which they don't attach, are still in force. I think under those circumstances, my response is either that you could give them a redacted version with just those provisions, or go back to the prior employer and say, look, I'm interviewing with people. What am I supposed to do when they ask me about restrictive covenants, and get some guidance from them? An email would, in my mind, be enough, where you could probably work out a deal that says, if I redact the financial aspects of this. Can I show this to them? But that's a fair point. And I think this is the final question. What if people know where Bob Smith is going to work and the new employer starts to receive work applications without Bob Smith's involvement? Is that going to be a problem for the new employer? No and yes is my answer. That in and of itself is absolutely legally fine. But proving that that's how it happened is going to be the issue. And so what I do, I've had circumstances where I've had a client who's going after a large group of people at a competitor, and we've created procedures for them to keep records of what they're doing, and have reminded them over and over again that they may not talk to Bob Smith. And we've given Bob Smith, or the Bob Smiths of the world, instructions about what to do if anybody contacts them. And I will say that where we've been able to tell the other employer, the target of all of that effort, look, we have procedures and we follow the procedures, and we can tell you with confidence that these people were found either by a third-party recruiting company or by going into publicly available information, or because those people were contacting us. There's a high bar to going into court on these things. And I have yet to have a case actually go to court where we've been able to affirmatively demonstrate, maybe not with a million documents, but just talking it through with them. And unless, and what I find is that unless they have somebody in the company who said, Bob Smith called me, it's harder for them to go after the company. So Mark has something in the franchise disclosure document. Yeah, so it's $100,000 a year limit, and it's void and unenforceable against an independent contractor of a franchisee if they don't make more than 250,000. So that's a specific franchise example. I don't know whether that number has changed because the numbers do go up over time. Okay. But yes, I mean, this is also why every circumstance is specific. You want to think about the profession they're in. So I think those are all the questions, and I think we've reached our hour.
We have. I want to thank you so very much. This was a great class, Sarah. Thank you again for presenting. And I'm going to just put up the poll now so people can start taking it.